Your patent sucks. The limitations of right to use and freedom to operate searches. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. So, one thing that people who do what I do for a living get asked to do from time to time is a right to use or freedom to operate search. And people do this when they're commercializing a product and they want to make sure they don't infringe a pre-existing patent that's still in force. And it's good to do that to stay out of trouble when you're releasing a product. Unfortunately, I think they often misapprehend. I know they do because I've dealt with it. They misapprehend the difficulty that's inherent in this process. So what's usually going on is you've got an invention and you're going to commercialize it. So if you do a patentability search, you're looking at the thing you think is new, and you're saying, is it new, right? So you're going to focus on this one piece of a product, right? It's going to be a little piece of a product that you think is the invention. I'm going to look at all this pre-existing prior art and say, is what I've got here new relative to all that stuff? But when you're looking at the freedom to operate side, it's a very different problem that you're facing. Your concern is not whether this little thing that you think is new is in fact new. Your concern is this product in which this little thing is incorporated going to infringe somebody's patent if I release it into the stream of commerce? And so the problem is you can't now just worry about the little thing that you thought was new, because anything that's in the product potentially can be fair game for a pre-existing patent, even if it has absolutely nothing to do with the thing that you think is patentable. And it just depends what your technology area is, what the level of patenting in that area is, and how much of your design is potentially straying into areas that are heavily patented. And the problem is too, it's like you can't search everything. It would cost a fortune. So you got to choose your battles and to spend your money wisely and do your due diligence, but you can't really cover everything. And so you do the best job you can, and you definitely want to focus on the thing that's new to some extent, because like if you have a new improvement and someone else has a bigger, earlier patent claim that subsumes that improvement, then yeah, you're going to be infringing by virtue of practicing the improvement. But there could be a whole lot of other stuff in the product that's a problem. And think, if you will, think about smartphones. If you remember the smartphone wars between Apple and Samsung, right? Those cases, they involved all these widely different features of the phones, from the way that the phone appeared in design patents, to the swiping features, to the autofill features. There were all these different things that could be implicated. I mean, if you were to release a smartphone and you had to search every one of those areas, that could, every type of thing on the phone that could possibly be at issue in a pre-existing patent, it would cost a fortune. So it's like anything else. It's a due diligence activity, and there's a risk reward to it, and you have to sort of do the best job you can. Now, I mean, you as inventors or as the client, what you should be doing is thinking about what you're doing in the product and whether you're aware of any other companies that are doing something similar. So even though you have this novel piece, you are aware of things you might want to look at outside of the point of novelty to see if the product itself might be infringing. So you do want to do that thought exercise and work with your patent attorney so that you can formulate a search that makes sense. It may be that the product is really cutting edge and that it's got a lot of features that might be important, not just the ones that you're patenting, and that there's a lot of patents still in force that you might run into. Now, keep in mind with the right to use search that you're only looking for unexpired patents, and it's the claims that matter, because what you're looking for is whether the product will infringe the claims. So it's not an issue whether it's in the specification or the drawings, whether some features in there. The question is, are there any claims for which your product practices every single element of the claim? And is that claim, unexpired? And is it in a patent that's in a country where you're going to make, use, or sell the product or import the product? That's really the issue. So when you're on a patentability side, you look at the whole document and you have to worry about every country in the world because it can be prior art from anywhere. But on the right to use side, you really only worry about where you're going to be putting the product into the stream of commerce. And then, you're really only worried about the claims. But even then, it can be a real chore. And you just have to keep in mind that there are limitations to what you can cover based on your resources. And you do the best job you can to establish reasonable due diligence in your efforts to avoid patent infringement. So I hope that helps keep you out of trouble, and I hope to see you here soon.